It refers to the earlier incident in the case of erstwhile state of Travancore and Cochin, probably also under 356. May not have been challenged in that case.
Not to my knowledge, my lord, it was not.
Paragraph 95 it refers to.
Paragraph, my lord, your lordship, sir.
5.
Novel situation has been taken place in past. Punjab was passed. Further, the erstwhile state of Travancore, Cochin was also reorganized during Article 356. Lord, in both the cases, the views were not taken.
Possibly it takes into account sometimes there may be a breakdown of constitutional machinery within the state when the reorganization itself
Is the solution. When there is a, my lord, kindly appreciate, my lord, why this, my lord. I'm sorry, not kindly, my lord, consider this. Lord, when the reason for imposition of the precedent rule is such that to bring that state out of the situation which resulted into imposition of precedence rule, maybe state requires to be reorganized. Then, my lord, the position cannot continue as it is. The President of India can take a call that the only solution of the problem is reorganization of the state. And your lordships are, my lord, the arguments repeatedly advanced was that there is a retrograde step. We were brought down from state to UT state. I will show, my lord, from the reorganization. It's a state for all purposes. It's a state with legislature, with only power of police with the president. It's a detailed state reorganization. Everything was factually wrong, that my consolidated fund has gone, my representation in parliament has gone, my election voting in president's election is gone. Specific statutory provisions are made. GST council is gone. These are the arguments which were. So, I am coming to that reorganization. The UT, my lord, is essentially as much a part of federal structure as any other state. In a given set of facts, Lord, your lordships have, my lord, I don't want to jumble up, my lord, my submissions, but there are, my lord, submissions. What would be the contours of your lordship's examination once your lordship finds that 356 exercise was not to be faulted with? What happens thereafter? There would be a restricted scope of judicial review. That's what Bomai has said. It's a narrow compass doctrine. No? Your lordships are aware. Lord, I'll take your lordship through that. But here, to obviate that also, the views of the parliament situations where it is necessary that for some time this remains under union, as union territory. And the Honorable Home Minister on the floor of the House has said that this is a temporary measure, ultimately it will become a state. But that's a separate argument, but I'll come to that. Lord, now, I may, my lord, complete, my lord, my written submission, my list of dates, my lord.
What page?
My lord, I was at page 102, my lord. But before that, my lord, I wanted your lordships to read one judgment. My lord, 102. Let me, my lord, complete this stepwise, my lord. My lord, step 1, your lordships have seen, no?
No, we were going to read that actually, right? We were just going to read that actually.
Yes. No, your lordships are at step 1, my lord.
We are now at step 1.
Yes, bro. Please see, my lord. As a first step, the Honorable President issued CO 272 by the said constitutional order issued under 370 subarticle 1, that is D. The President applied all provisions of the Constitution of India and superseded all previous Constitution orders by which selected provisions of the Constitution of India were made applicable either with or without modifications.
Just 1 second.
I'm sorry, my lord. My lord, Justice call gets, my lord.
Point number 1.
Point number 1. Step number 1. As a first step, the Honorable President issued CO 272 by the said Constitution order issued under Article 370 subarticle 1. The President applied all provisions of the Constitution of India and superseded all previous constitution orders by which selected provisions of the Constitution of India were made applicable either with or without modifications. And two, the Honorable President applied Article 367. Your Lordships have seen it has been applied 4 times in past of the Constitution of India as modified under the said order in which modification was made in Article 367, sub-article 4. Please see, my lord, at D. This is the exercise which is, my lord, approved in Damnu. D. In proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall read Legislative Assembly of the state. This is the first step. My lord, when I explain this, my lord, I'll assist your lordships that in absence of an assembly, constituent assembly, my contention in law is that the president is free to take a call, even without recommendation, but I'll come to that little later. Step 2. After having applied the entire constitution with modification as stipulated in 367(4)(d), as reflected above, because we had to, my lord, save 367 because that's the mechanism we have used. Reflected above, the Parliament after CO 272 was placed before it, undertook the following exercise in its capacity as the legislator of the state. Then, my lord, Rajya Sabha recommended to the president under Article 370, sub-article 3 as under. Now, Rajya Sabha as a legislative assembly recommends, please see, my lord, the bottom, that this house recommends the following public notification to be issued by the President of India under Article 370, sub-article 3. Please see, my lord, the next para. All provisions of this Constitution as amended from time to time without any modifications or exceptions shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or Article 308 or any other article of this Constitution or any other provision of the Constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, bylaw, rule, regulation, notification, custom or usage having the force of law in the territory of India or any other instrument, treaty or agreement as envisaged under Article 363. But simultaneously, on bill being sent to Rajya Sabha under proviso to Article 3, Lord, which according to me, I can safely argue not necessary in absence of the legislature views. I'll show the Mangal Singh judgment. But it was placed before the Rajya Sabha as a legislature. First step of legislature, because second is Lok Sabha. Rajya Sabha expressed its view to accept Jammu and Kashmir Reorganization Bill as under, that the President of India has referred the Jammu and Kashmir Reorganization Bill to this House under the proviso to Article 3 of the Constitution of India for its views, as this House is vested with the power of state legislature of Jammu and Kashmir as per proclamation of the President of India dated 19th December 2018. This House resolves to express the view to accept the Jammu and Kashmir Reorganization Bill. Simultaneously, on the bill being sent to Rajya Sabha under proviso to Article 3, the President, the Lok Sabha expressed its view. After Rajya Sabha, Lok Sabha, so that it whole becomes the legislature. They also, my lord, accepts the, thereafter, my lord, Rajya Sabha passes Jammu and Kashmir Reorganization Act 2019, after views of, my lord, both the houses. Now, your lordships may skip the note and kindly come to page 106 bottom. Next day, 6th of August 2019. The lordships have seen, my lord, the recommendation of the Rajya Sabha acting as a legislature under Article 370, sub-article 3. Now it comes before Lok Sabha. On 6th August 2019, again the Parliament commenced its proceedings exercising its function as legislative assembly of Jammu and Kashmir. The following legislative activity took place. Lok Sabha recommended to the President under Article 370, sub-Article 3, not same, I'm not reading it, recommending to the President that you apply all provisions of the Constitution as was recommended by Rajya Sabha. And Lok Sabha passed Jammu and Kashmir Reorganization Act because the views were expressed the previous day. So both the views and act, it becomes an act, namely Jammu and Kashmir Reorganization Act, and both the recommendations which now culminates into Lord 263, CO 273, I'm sorry, 273. Lord, please see page 108. Further, in the appendix to the bill, a comprehensive schedule contained the list of central laws made under the union list and the concurrent list by the parliament, which would henceforth be applicable to the union territory of Jammu and Kashmir and union territory of Ladakh. The amendments have also been carried out to the existing state laws made under the state list by the erstwhile state legislature in order to bring them in line with all provisions of the Constitution of India. So they become now Constitution compliant. It is critical to note that the said Reorganization Act applies an already existing constitutional provision, that is Article 239A, to the region. It is stated that the same counters the assertion of the petitioners that it was in breach of federal structure. It is stated that Article 239A itself is a part of federal or asymmetrical federal structure and cannot divorce the concept from the landscape of Indian constitutional law. Article 239A, applicable to Puducherry for decades, is one of the ways of maintaining federal relationship between region and center and cannot be said to be arbitrary and irrational. Then step 4 and the last step, CO 273. President issued CO 273 in exercise of powers under Article 370, sub-Article 3 of the Constitution as amended by CO 272, declared that Article 370 would cease to apply with effect from 6/8/29. This is what is impugned. Thereafter, my lord,
This may be your answer as far as Ladakh is concerned, but converting J&K into a union territory, what is being argued by the other side is downgrading.
I must meet with them.
That argument, number one. Number two is Article 356, the maximum tenure as prescribed is 3 years. We have crossed those 3 years.
At the time of, my lord, I'll answer that, my lord, but 2019 we have not. And thereafter, my lord, we are in a different regime.
No, I know. Now, as a union territory, that 356, that part will not apply because union territory is something different.
Is, my lord, therefore, my lord,
But if it was not a union territory, then
it
that
would have crossed. It would have crossed by now. But for the intervention of 5th and 6th August 2019.
yes, that's
Yes. Lord, for your lordship's convenience, I have prepared, my lord, a chart. This is only section and the article and how it changes. It would be for quick reference, my lord, if your lordship permits. It's not nothing new. Nothing new, my lord. But 367 application, my lord, is little confusing if we read from various pages. Therefore, my lord, we have just made a common kind of a 3-page chart.
as far as 367 is concerned.
Only 367.
367, because there was some deletion also in 367.
Therefore, my lord, please, my lord, it won't take more than 5 minutes, my lord. Kindly pardon me, my lord, this, I think, better to have the physical copy, my lords, because it's big, larger. Lord, left-hand side is the Article 370 as it stood on the date of my lord, Constitution coming into force. Correct, my lord? Right-hand side is as on 17/11/52, CO 44. My lord, the change made under 370 sub-article 3. Please see the color part. My lord, your lordships, I think, my lord, the Chief Justice is ahead of me, my lord.
Yes. The first-
Always so, my lord, but even
No,
in
but
this chart.
Explanation, right? Explanation.
Explanation, for the purpose of this article, the government of state means, Lord, this is replaced by Sadr Riyasat. Please see.
Right.
Person for the time being recognized by the President on the recommendation of the Legislative Assembly as Maharaja of Jammu and Kashmir, acting on the advice of Council of Ministers for the time being in office under Maharaja's proclamation dated so and so. The person of, for the time being, recognized by the President on the recommendation of the, this is edit, the green part is addition, my lord. Green part, kindly, my lord, if your lordships can consider writing green part is addition. But please mark one thing, though, my lord, at that date, 17/11/52, the Constituent Assembly was in place. In 52, Constituent Assembly was in place, but only Legislative Assembly, my lord, was used while defining the state.
Right.
When there is a state, Legislative Assembly of the state, President on recommendation of Legislative Assembly of the state as Sadr Riyasat of Jammu and Kashmir. This is the first change.
But this was done pursuant to the recommendation given by the Constituent Assembly.
Correct. I have said so, my lord, in my written submissions as well. My lords are right. Thereafter, my lord, page 2, Lord, this is as on 14th May 54. The second change takes place.
Just one. This would be, this amendment which came as a result of, this is under Article 370, Clause 3.
First,
The first exercise.
first exercise.
This is,
Now-
this is under Article, Clause 3 of Article 370.
The first one, yes.
Because at that time, Constituent Assembly was there.
Was in force.
So they then, the
Recommended.
recommendation resulted in the amendment to the constitution. It got carried forward. Words which are not pre-consent.
May 1954, that is CO 48,
Yes, my lord. The entire green part is added, my lord.
under Article 367.
Yes, my lord. My lord, only D we have highlighted in yellow to, my lord, show to your lordships, my lord, I have already emphasized that reference to the legislature or the legislative assembly of the state shall construed as including reference of constituent assembly. So inclusive definition. So they were used interchangeably. Otherwise, my lord, this entire green part is added in 54 and its effect is given, my lord, on the right hand side.
Right.
It is the same thing and therefore I am not reading it, my lord. I have given the effect of the 367 exercise. Then, my lord, coming to page number 3, it is again, my lord, under 367, where D, your lordships would find in red is deleted. Correct, my lords?
Right.
The reference to legislature or the legislative assembly is deleted and, my lord, green is added. What is deleted, my lord, is in red. Raj Pramukh reference goes, my lord, in 58 because of, I have pointed out, Reorganization Act, etc. and, my lord, Article 238, my lord, being repealed. Reference to a governor shall include reference to the governor of Jammu and Kashmir, provided that in respect of any period prior to the 10th day of April 55, such referendum that is for the past period. So now, now comes the governor because Sadr Riyasat ceases to exist and therefore the governor. Right hand side, I have given effect to this amendment.
CO 56 came in after the constitution was framed. in
Correct.
Jammu and Kashmir after 26 January 1957.
My lords are right.
So therefore, the reference to the Constituent Assembly is done away with in the
Deleted.
Article 367
Deleted.
interpretation.
But exercising the mechanism under 367. That's the, Lord, I wish to highlight. Otherwise, that's the two reasons. A, Constituent Assembly was not there, and governor because of state reorganization. Now, my lord, A is the new addition. My lord, this is 66. My lord, this is the left-hand side on page 4 is what the AMNU judgment, my lord, approves. That 367 can be used for this purpose. A is addition, reference to the person for the time being recognized by the President on the recommendation of Legislative Assembly of the state as Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. And, my lord,
But Sadr-e Riyasat had already gone, right?
yes, ma'am.
So then what was the need for bringing this in 1966?
No, I'm sorry, Sadr-e Riyasat went here.
Oh, it went
I'm
here,
sorry,
that's
it went
right.
here.
Riyasat was earlier there.
Earlier, it was removed from B, 4B. I'm sorry, B, it remained, it went in E. E. Now it goes from B as well.
Earlier, the amendment was Sadr-e Riyasat acting on the advice of the Council of Ministers. Earlier, it was individual capacity, then it became acting
Yes.
on the advice of Council of Ministers. Here now, the Sadr-e Riyasat is replaced by Governor.
Governor acting on the aid
Right.
advice. Yes, ma'am. Now, my lord, the last one at page 5, Lord, which is done by CO 272, the impugned one, my lord, page 5. The proviso is added. The exercise which was undertaken so far under 367 was again undertaken for the purpose of Jammu and Kashmir. For Article 370, the word Constituent Assembly was replaced by the word Legislative Assembly. Same thing, because Constituent Assembly ceased to exist, it became Legislative Assembly now. And my lord, the rest, I have, my lord, already explained.